Is that okay? All righty. So,
Thank you.
yeah, it's been kind of another slow year at the Supreme Court, right? I mean, not much. I'll try to spice it up, but that's going to be difficult. So the roaring conservative backlash, and as I always say at the beginning, as kind of a caveat, I mean, I have my own preferences like you do, but when I say conservative, I'm not necessarily talking about good or bad, wise or foolish. I'm talking about conservative in the sense that we usually mean that term, especially in judicial studies. We're talking about political, ideological, cultural conservatism. Just think of how a conservative Republican politician might vote, right? As opposed to a liberal Democratic politician might vote. And the backlash, it is a backlash. Sometimes we forget that. There may be one or two of us in the audience who remember the court under Chief Justice Earl Warren. And we remember when that court began in 1954. Right now you're shocked. You're saying, Bonventre's that old? Yeah, Bonventre's that old. Or I was around in 1954 when Brown versus Board of Education was decided by the court under Earl Warren, prohibiting as unconstitutional racial segregation in public education. And half of the country went crazy. Eisenhower had to send the troops in. We had all the kinds of complaints we still hear today in certain quarters about the Supreme Court. The court's activist. These kind of issues should be left to the states. Racial segregation has been part of the history and tradition of this country. Desegregation is not mentioned in the Constitution. We continue to hear those kinds of arguments today. The court under Chief Justice Earl Warren then went on to take the rights under the Constitution, whether they're mentioned in the Bill of Rights or not mentioned in the Bill of Rights, but fundamental constitutional rights for an American society, took those rights seriously, perhaps for the first time in the history of the court. So, for example, rights of the accused, whether we're talking about search and seizure, whether we're talking about double jeopardy, speedy trial, right to counsel, privilege against compulsory self-incrimination, free exercise of religion, separation of church and state, free speech, all of those actually came to fruition as we know them today during the years of the court under Chief Justice Earl Warren from 1954 through 1968. And when I say backlash, what I'm talking about is a continuing reaction, right? Continuing reaction, trying to reverse what happened during those years. And in fact, many of the justices on the court who have been the most conservative, again, for good or bad, wise or foolish, they have been reacting to what happened under Chief Justice Earl Warren. And they've been trying to get the court to either dilute or, as we've been seeing, overrule what the court did during those years. And even those who were too young, perhaps, to have been around during that era, the Republican appointees, they grew up and they went to law school, and their mentors were those who also were repulsed by what happened during the tenure of Chief Justice Earl Warren. Now, for many of us, I suppose, we think, well, how is that? How is that possible? Most of what was done during that era we cherish as landmarks. Well, when we hear about textualism, originalism, history and tradition of the country, whether the constitutional document mentions such things, whether we ought to leave such things up to the states, whether this is part of the judicial role, most of those arguments emerged during that era where the United States Supreme Court finally took constitutional rights seriously. Perhaps those rights should have been taken seriously by the other branches and by the states. And the argument is, yes, it was up to the other branches and the states, not the court. So we have seen the past couple of years, but it seemed to reach a peak this past year, this backlash. Oop, there they are, the justices of the court. Let's see, and you know, that's the Chief Justice, John Roberts, Clarence Thomas, Stephen Breyer, Samuel Alito, Sonia Sotomayor, Elena Kagan, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. And more about them in a little while. Here's another way of looking at the court. 66% of the cases the United States Supreme Court decided as a conservative Republican politician would decide. Again, I'm not talking about activism or restraint. That's usually a lot of nonsense. I'm not talking about originalism, what the founders actually meant. That's usually a lot of nonsense as well. That doesn't mean that those kinds of approaches wouldn't be legitimate. But you really have to be kidding yourself to think that that's what the justices are doing. They're not doing that. The best way to predict how most of the justices are voting is to determine, were they Democratic appointees, how would liberal Democratic politicians vote? Republican appointees, how would conservative Republican politicians vote? 66% conservative. Let's put this in perspective. By the time a case gets to the United States Supreme Court, it is extraordinarily close, at least as a legal matter. Now, perhaps as a sociological matter, as a political matter in the Aristotelian sense, maybe they're not close. I mean, it would be much wiser for a free society for the court to decide this way or that way. But as a purely legalistic matter, these cases are close. That's why they're there. They're usually there at the United States Supreme Court because the courts below are divided. They're deeply divided. Or because an area of the law is just entirely unsettled. Why is it unsettled? Either because there are precedents and statutes one way, but there are also precedents and statutes the other way, or constitutional provisions which seem to suggest this, others which seem to suggest that, and the court must choose between this pile of legal materials and that pile of legal materials. Now, we can be ideologically blind and say, oh yeah, the law is clear. No, the law is not clear, which is why the cases are there. With regard to those very close cases, 2/3 of the time, they're very close. 2/3 of the time, the court voted in an ideologically conservative fashion. Now, let's pick on the liberals for a while. Sotomayor. These very, very close cases. And the past year, there were 40. There were 40 where you could definitely say there's a liberal versus conservative aspect to the case. Sotomayor, in one case she saw any merit on the other side. And Kagan and Breyer, just a couple of more. Remember, these are incredibly close cases. Let's go to the other side, which may be more fun to some of us. Thomas and Alito, they virtually never see any merit on the other side. Now, Breyer is the least liberal of the liberals. Roberts, Chief Justice Roberts, is the least conservative of the conservatives. And how many times more conservative is he? 5 times more conservative, right, than the liberal who's the least liberal. Look at that divide. Oh, it just happens to be these are Republican appointees. It just happened to be these are Democratic appointees, which is one of the reasons why, not only among the public, but certainly among constitutional scholars, this court has lost so much respect. That's the court right now, right? Sotomayor, Breyer, Kagan. And then you have 4 really hardcore conservatives. And then you have 2 centrists. It's quite a surprise for many that Brett Kavanaugh actually has become fairly moderate on the United States Supreme Court. Perhaps he always was fairly moderate. And the Chief Justice, we know, has been trying to moderate that court. And of course, we lost Ruth Bader Ginsburg, and she was replaced by Amy Coney Barrett. Let me show you this one. Look at Ginsburg, 4%. Okay, just like Sotomayor, she virtually never saw merit in the other side. God bless her. But, you know, the last 10 years or so, she was on the court. I mean, the republic was going to fall, you know, whenever the court didn't go her way. But she virtually never saw merit in the other side. Look at this. Instead of being 2/3 conservative, it would have been about half and half. Would have been about half and half. There's Barrett, 74%. Let me go back. Ginsburg, 4%. Huge difference. Huge difference. Okay. Here's another thing. This was put together by Lee Epstein, who probably is the foremost social scientist who studies the United States Supreme Court. And I know this may sound counterintuitive, but the most eminent Supreme Court and constitutional law scholars are actually social scientists. Those are the ones who look at all the voting, try to figure out what's actually going on, as opposed to those of us who are lawyers. We put on our lawyer hat as, well, you can distinguish this case from that case. And yeah, this court distinguished this line of precedence. Okay, come on, no. As I tell my students, no, there's just different justices on the court. And they have very different views. And so they're taking the law in a different direction. Well, look at this. This last year, according to Lee Epstein, if you looked at all the cases, majority and divided, 74% conservative, 74%. Although she's saying non-unanimous, but she's not necessarily talking about those where it's a very, very clear, controversial, hot-button issue, as I was doing. 74%. The last time the court was more conservative than that was in the pre-New Deal and the New Deal era, when FDR wanted to pack the court because the court continuously would invalidate social welfare legislation. If it was the federal government trying to legislate for Social Security, workers' rights, unions, minimum wages, maximum hours, clean water, air, child labor, all those things, the United States Supreme Court would repeatedly invalidate those. Oh, what it would say is we have to leave those up to the states. Oh, yeah. When the states would do the same thing, the court would invalidate what the states had done. And they would come up with a different reason. The fact of the matter is, it was just a very pro-business, very ideologically conservative court who didn't want either the states or the federal government to start legislating social welfare, socialism. That was the last time the court was more conservative than it is today. Okay, the justices. Clarence Thomas, been on the court for, he's 74 years old. He's been on the court for 31 years. Does that make sense? You know, some of us don't think it makes sense whether it's Clarence Thomas or Ruth Bader Ginsburg for somebody to be on the court for 31 years. And there's plenty of proposals out there right now to try to change this. Very conservative, right? Stephen Breyer, he retired. He was 84. He had been on the court for 28 years. Clinton appointee, liberal. George W. Bush appointees. The Chief Justice, Roberts, 68. He's been on the court. He's been on the court for 17 years already. Word. I remember yesterday, him before the Senate Judiciary Committee. We're like umpires. We just called balls and strikes. That being said, regardless of how ridiculous that is, he really has turned out to be a really fine justice, whether you're a liberal or conservative. I mean, he really is a fine justice. I wouldn't necessarily vote like him most of the time, but you got to give him, he's really terrific. It kind of reminds me of William Rehnquist. I don't think I would ever vote like William Rehnquist, except maybe when he saved Miranda warnings. But I was literally at the court at the time when Rehnquist took over as Chief Justice. And I have to say, everybody in the building was happy. The liberals and the conservatives were happy because William Rehnquist was brilliant and he was very respectful of everybody's views. So Chief Justice John Roberts, probably the most respected member of the court. Samuel Alito, 72, been on the court for 16 years. Very conservative, and he's become increasingly conservative and increasingly bitter. It probably didn't help the way the Democrats in the Senate confirmation savaged him, right, during those hearings. But he's become increasingly bitter and conservative, especially now that he knows he's got the court. Now that he knows he's got the court. Barack Obama appointee Sonia Sotomayor, 68, 13 years on the court. Very, very liberal. Elena Kagan, 62, 12 years on the court. Liberal, not quite as liberal as Sonia Sotomayor or Ginsburg. The Donald Trump appointees, Neil Gorsuch, 55. He's been on the court for 5 years already. Very conservative. Just imagine how much longer he's going to be on the court. Since they usually stay on the court till they're about 83 or 84. Brett Kavanaugh, 57, but on the court for 4 years. Conservative, not quite as conservative as Gorsuch. Amy Coney Barrett, 50 years. 2 years on the court already. Conservative, again, not quite as conservative as Clarence Thomas, Samuel Alito, or Gorsuch. And the new justice, Ketanji Brown Jackson, 52. She's been on the court, well, now for 2 months she's been on the court, and a liberal Democrat. We're not quite sure how liberal she's going to be, but there's no question about it. She's going to be a liberal. I know Biden and the Democrats are saying, oh, she's mainstream. She's not really one way or the other. Yes, she is. If you look at her record, she's definitely a liberal. Again, good or bad, she's definitely a liberal. All right, and there's, again, Lee Epstein looking at, in her view, what the ideological spectrum of the court is, with Alito and Thomas all the way at one end, Sonia Sotomayor at the other. All right, I thought this was interesting. It's the first time I did it this year when I spoke about the Supreme Court. Looked at the predecessors. This is really remarkable. Shocking to some of us who are liberals. Thurgood Marshall, right? Thurgood Marshall, known to be one of the great civil rights litigators in the history of this country, right? Who was then the Solicitor General under Lyndon Baines Johnson, and then Lyndon Baines Johnson appointed him the first African American to the court. Very, very liberal. He was replaced by Clarence Thomas. Can you imagine what a huge change that is? Huge. One very, very ideologically liberal. The other very, very ideologically conservative. Harry Blackmun, a Republican appointed by Nixon. He became a disappointment for Nixon because as the years went on, either he became wiser or senile, and he became very, very liberal. Right? He became very liberal, and we know him most famously as the author of Roe versus Wade, The Right to Choose. He was replaced by Stephen Breyer, the Clinton appointee. Really no change there. William Rehnquist, he was appointed to the court by Nixon, who referred to him as Wrenchberg, had no idea who he was, but everybody was telling me, you know that guy that works in the Department of Justice? The guy's really brilliant. Oh, yeah. And then when he met with Rehnquist, who again he called Wrenchberg, apparently his number one comment was, the guy dresses like a clown. And I know exactly what he meant, because whenever I would see Rehnquist at the court, he was always wearing corduroys, right? Corduroys, and I don't know, his jacket looked like he got it from Salvation Army, God bless him. And he wore one of those cloth ties, you know, and like a big buckle. So that wasn't exactly what Nixon or Chief Justice Burger thought a judge ought to dress like. But absolutely brilliant and very, very conservative. And his former clerk, John Roberts, took over for him. So a little bit of a change, not quite as conservative, but basically the same. Here's another huge change. We had Thurgood Marshall and Clarence Thomas. Now we have Sandra Day O'Connor. Sandra Day O'Connor, appointed by Reagan. He wanted to appoint the first woman to the court. And Barry Goldwater very strongly encouraged him to appoint Sandra Day O'Connor, who was an intermediate court judge in Arizona. Definitely a Republican. Definitely started out as a conservative. But as she said, Clarence Thomas and Scalia pushed her over to the left. Of course, there probably were other reasons why she ended up being more liberal than she had been at the beginning. But she was definitely a moderate Republican. Think affirmative action. She voted in favor of it. Gay rights. She voted in favor of it. Right to choose. She voted in favor of it. In fact, she's the one who saved it. Samuel Alito. Huge change. Very, very conservative. In fact, many of my colleagues think that's the worst replacement on the court right now, going from Sandra Day O'Connor to Samuel Alito. Of course, if you're conservative, it's great. It's great because the conservatives ended up really disliking Sandra Day O'Connor. They really thought she was a traitor. David Souter, the conservative Republicans disliked him intensely as well. They believed they were sold a bill of goods. If they listened to the man at the confirmation proceedings, they would have known the man was a flaming liberal. I remember I called up my mentor, Henry Abraham, and I said, Uncle Henry, I said, are you listening to Souter? He's supposed to be conservative. Then he's very liberal. Yeah. So we weren't surprised, but the Republicans made believe they were surprised, so maybe they were. Very liberal on the court, and he was replaced by Sonia Sotomayor, so not much of a change there. John Paul Stevens, Gerald Ford appointed him. He was a very non-controversial choice. He had the respect of just about everybody. He was a moderately conservative Republican. Again, either increased wisdom or senility. He ended up being the leader of the liberal wing on the court. Elena Kagan, also a liberal. Not too much of a change there. Antonin Scalia, a Reagan appointee, very, very conservative. Neil Gorsuch, who hero worships. Scalia, also very, very conservative. Not much of a difference in their voting pattern. There is a difference. Scalia was brilliant. I think many people think he's kind of the dimmest wit on the court, Gorsuch. He's also probably the least liked on the court. He always feels the need to write a separate concurring opinion to show why the court should have decided the case and adopted certain doctrines that he thought were preferable than the majority. I actually had a student in my class a couple of years ago who escorted Gorsuch when he went through the Senate confirmation. And this fella escorted first ladies, presidents, other nominees. He said this was the only one he could not stand. He said he was like this. Yeah, he said he just couldn't stand him. Liked his wife, couldn't stand him. Anyway. Anthony Kennedy, Reagan appointee, moderate Republican, another real disappointment to the conservative Republicans, affirmative action, gay rights, right to choose. And Brett Kavanaugh, he's a conservative Republican, not nearly as conservative as the liberals were afraid he'd be, or the conservatives hoped he would be. Ruth Bader Ginsburg, Clinton appointee, very, very liberal, what Thurgood Marshall was for civil rights in the racial realm. She was with regard to gender discrimination and gender equality. She's replaced by Amy Coney Barrett, very, very conservative. Those who are liberals, perhaps there is some hope for her. She's very, very bright, and she seems to be much, much more measured than either Alito or Thomas or Gorsuch are. We'll see. Okay, there's the court. Not going to change with Ketanji Jackson. The first Roberts court, look at that. There were 4 liberals on the court when Roberts became chief. There were 2 hard-right conservatives. You had 2 real centrists. You had Kennedy and O'Connor, right? So you had 4 liberals. All they needed was to get Kennedy or O'Connor. Look at the predecessor court. Marshall, Ginsburg, Souter, Blackmun, Stevens. You had 5 liberals on the court. They didn't need anybody else's vote. Right? Just think of all these issues. How the liberals would vote: abortion, gun rights, separation church and state, vaccination mandates. How is vaccination mandate a partisan issue? How is that? Well, because conservative Republican politicians don't like it. What that has to do with the law and justice on the Supreme Court is another story, but that seems to be what motivates them. Campaign finance, Trump, anything having to do with Trump, voting restrictions, anti-discrimination laws, racial issues, immigration, death penalty, rights of the accused, environmental issues, worker rights, consumer rights. We know how the predecessor justices would have voted on all of these. Okay, Roe. Let's talk about Roe. Samuel Alito wrote the majority opinion for the court. The 5-4 court to overrule Roe, 6-3 court to uphold the Mississippi 15-week abortion restriction. Justice Thomas wrote a concurring opinion in which he said, since we've done this, parenthetically, the arguments that have been made in this case would certainly lead us to overrule other precedents, such as contraceptive rights, such as gay rights. He didn't say mixed marriage rights, but we'll take a look at that in a bit. Actually, I don't have it outlined here, but Brett Kavanaugh also wrote a concurring opinion saying, no, we're not going to overrule those cases. Well, the three liberals on the court, by and large, they were talking about precedent, probably the weakest argument they could have. Liberals, we don't necessarily stand up for precedent, okay? That's not a great argument for us. The landmarks we love all overruled slews of precedents. But that was basically the argument. Chief Justice Roberts said, let's uphold Mississippi 15-week restriction, but also maintain Roe versus Wade, the right to choose. Samuel Alito, right to abortion is not in the text. It's not part of the history and tradition of this country. We'll take a look at that. But first, I want to look at the liberals' argument. I mean, give me a break. Brown versus Board of Education, right? 68 years. Does that mean we should have upheld Plessy versus Ferguson because it was a 68? Oh, it's a super precedent. It's a settled precedent. No. Loving versus Virginia. Even more so, look at this. 84 years? You're my math expert. 84 years. Should we upheld Pace versus Alabama? They convicted, threw in jail, an African-American man who fornicated with a white woman, right? Supreme Court upheld that, right? Overruled that in 1967, Loving versus Virginia. West Virginia versus Barnett, 3 years later. That was originally the Supreme Court said, it's perfectly fine to throw the Jehovah's Witness parents in jail or to fine them and expel their children because they refuse to pledge allegiance to the flag. Because in their religion, they only pledge allegiance to Jehovah, right? 3 years later, West Virginia versus Barnett, written by Justice Jackson, thank you, written by Justice Jackson, and one of the most gorgeous opinions in the history of the United States Supreme Court, overruled that and said, no, free exercise of religion and freedom of speech. You can't do that to the Jehovah's Witnesses. West Coast Hotel versus Parrish, 1937. It overruled a whole slew of cases that we know as the Lochner era. That's the era when the Supreme Court was invalidating all those social welfare pieces of legislation: maximum hours, minimum wages, worker safety, consumer rights, food and drug, all those kinds of things. Social Security, 1937, we call that the switch in time that saves nine. One of the justices on the court switched the way he voted, started voting with the liberals who wanted to uphold those social welfare pieces of law. And the court ultimately, after 37, just started overruling all of those cases, a whole bunch of them. Gideon versus Wainwright, Betts versus Brady, 1942, said, well, you know what Benjamin Cardozo said in Polko versus Connecticut in 1937, that you can't possibly have a fair criminal justice system unless the defendant had an attorney. Well, we really didn't mean that. We only meant like in death penalty cases and other special cases. Well, Hugo Black, Justice Hugo Black, dissented in that case. 21 years later, he wrote the majority opinion overruling it. And that's why in America, every accused has the right to an attorney. I guess the liberals thought we should have stuck with Betts versus Brady, a nice precedent. And of course, we had all those precedents in the 1960s, right? All those landmarks which we cherish, which overruled generations and generations of precedents, whether it's search and seizure, cruel and unusual punishment, self-incrimination, double jeopardy, and on and on and on. And of course, most recently, Lawrence v. Texas overruled Bowers versus Hardwick and said, you know, Texas, Georgia, and the usual suspects, sorry, you can't throw people in jail for being gay and lesbian. The Supreme Court literally said they could in 1986. 2003, the court overruled that case. So let's stop this nonsense about precedent. I said the Brandeis dichotomy. Louis Brandeis, right, one of the great justices in the history of the court, one of the real liberals of the court, right, but also Justice Scalia and Chief Justice Rehnquist later on, they spoke about the Brandeis dichotomy. Now, Louis Brandeis, I talk about him like Louis, like he's my buddy. Justice Brandeis, right, he didn't call it the Brandeis dichotomy, they did. And what he said was, look, stare decisis, following precedent is important. But when it comes to constitutional matters, our errors can't be corrected except by the amendment process, and that's virtually impossible. So for constitutional matters, we should be much more willing to correct our errors and overrule our precedents. And in all these cases, we see the Brandeis dichotomy. Okay, the majority opinion, it's not in the text. I love this one because this one is one of the most ridiculous. Now, I'll go further. One of the most moronic arguments there is in constitutional law, but it's so appealing, and we keep hearing it repeated over and over again. The Constitution is not a catalog of our rights. It was never intended to be that. In fact, when a Bill of Rights was proposed, we almost didn't get it because many of them were afraid that if we put any rights in the Constitution at all, there would be an argument, well, this right's not in there, so the people don't have it. This right's not in there, so we don't have it. We keep hearing that argument today. All right, really, let's see what's in the Constitution and not. The right of a couple, even a traditional heterosexual one, to marry. Not mentioned. It ain't there. The right of a married couple to be intimate. Sorry, sex ain't mentioned in the Constitution. The right of the couple to kiss. That ain't in there. What about having children? That's not there. What about raising your children? What about hugging your children? What about looking for work to support yourself? What about having a friend? Joining a group of friends? Waving to a neighbor? Taking a stroll? Donating to your favorite charity? Offering your services to that charity? Marching in support of a cause? Walmart, you should pay your employees higher wages. Marching with placards. It ain't mentioned there. Speech is mentioned there. I think Jimmy Madison and his mother knew what the word speech meant, right? They weren't talking about parading. That may be part of the principle of free speech, but it's not in the text. Well, what about the rights that these guys like, that keep talking about it's not in the text? the right to contribute money to a political candidate? That's not there. It may be an expressive activity, but I'm sorry, expressive activity, those terms are not mentioned in the Constitution. The right of a corporation to finance a video about a candidate. That's Citizens United. They produced a video and they financed a video critical of Hillary Clinton. It ain't there. Constitution says speech. The right to have a parade, let alone the St. Patrick's Day parade, right, in Boston where you exclude gays and lesbians. It ain't there. Hunting. No, I'm sorry, that's not there. Self-defense, that's not there. What about the right to avoid and hate liberals? That ain't there. The right of a fetus or fertilized egg. That ain't there. Here's our boy Jimmy Madison, right? You want to be an originalist? Yeah, you all want to be originalists. Okay, so let's look at what Jimmy Madison said when he proposed the Bill of Rights. Let's zero in. It has been objected also against the Bill of Rights that by enumerating particular exceptions to the grant of power, it would disparage those rights which are not placed in that enumeration. It might follow by implication that those rights which are not singled out were intended to be assigned into the hands of the government and were consequently insecure. This is one of the most plausible arguments I have ever heard urged against the admission of a Bill of Rights. Thank you, Jimmy. Where are you when we need you? I have attempted, as gentlemen may see, by turning to the last clause of the fourth resolution, and that's the Ninth Amendment. What we have now is the Ninth Amendment, that just because we've enumerated certain rights does not mean that this is an exhaustive list. We're not disparaging any others. Look, Samuel Alito is a smart guy. He knows that. He knows that. The nation's history and tradition. Oh, okay. Not in the text, at least the nation's history and tradition. This comes right from his opinion. An unbroken tradition of prohibiting abortion. And then the 14th Amendment argument. 14th Amendment, 1868, that's when fundamental rights were made applicable to the states. Because as you know, the Bill of Rights itself only applies to the federal government. The 14th Amendment is what makes federal fundamental constitutional rights applicable to the states. So he says, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime. By the time of the adoption of the 14th Amendment, 3/4 of the states had made abortion a crime. He really was impressed by his own argument because he repeats it again. By 1868, when the 14th Amendment was ratified, 3/4 of the states, 28 out of 37. I didn't want to go on and put it down there 5 different times, but he kept repeating this, so let's see. Okay, desegregation. Here's the argument that Kansas made to continue to racially segregate its schools. The laws of majority states authorized segregation at the time of the 14th Amendment. Of the 37 states that comprised the Union at the time of the 14th Amendment, 24 of them maintained legal segregation. Too late in the day to say it's violative of fundamental rights, and this court ought not to get involved in it. This should be left to the states. Interracial marriage, right? This is from Virginia's brief. You like the way I went back to the briefs, right? I actually went back to the briefs, and it's like, oh, Lord, you know. Went back to the briefs. This is Virginia. A majority of the states which ratified the 14th Amendment still maintained and enforced their anti-miscegenation laws as late as 1950. Federal courts and state courts said this was perfectly fine. It's the exclusive province of the states. Courts stay out of it. Birth control. How the heck is birth control controversial? But this is one of the ones that Justice Thomas says, get rid of. Well, if you follow Samuel Alito's legal argument in the Dobbs case, you get rid of this. Well, you get rid of the others too. This is from Connecticut's brief. The Connecticut statute stems from the Federal Comstock Act of 1873, prohibited the possession, sale, mailing of contraception. As of 1964, 30 states of the Union still had a statute applicable to preventing contraception. Right? After the Federal Comstock Act of 1873 was enacted, a majority of the states passed statutes designed to prevent the sale of contraceptives. Gay rights. This is Texas. In light of the pervasive state criminalization of such conduct throughout the nation's history, it cannot seriously be asserted that the right to engage in homosexual sodomy. They don't speak in terms of LGBTQ rights. They speak in terms of homosexual sodomy. The last time I was with Antonin Scalia, it was not just him and me. It was at a lecture for Henry Abraham. And Scalia's lecture had absolutely nothing whatsoever to do with homosexual sodomy. And yet he kept referring to homosexual sodomy. At the end of then after the lecture and everything, which is open to the whole community, a few of us go out to dinner with our mentor, including Justice Scalia. By the way, Henry Abraham's wife, Mildred, refused to sit at the head table with Antonin Scalia. But anyway, so at the end of the dinner, you know, people have to get up and say how honored they are to have Antonin Scalia there. He says, okay, I have to say something. He stands up and he starts talking about how great it is to be here, and then he starts talking about homosexual sodomy, whether it's a fundamental right or not. I mean, you know what they say, right? Yeah, yeah. Last year, my Supreme Court class, I played a debate between Scalia and Justice Breyer. And it was about international law. All of a sudden, Scalia starts talking about homosexual sodomy. After he mentioned it the third time, my students start shouting out, 3, 4. Well, for some people, it really gets to them. You know, they're brought up, you know. Anyway, it was punishable as a crime in all but 5 of the 37 states. Ratification of the 14th Amendment. With regard to all of these, just replace right to choose. Gender equality. My students are always shocked. It was not until 1971 that the United States Supreme Court finally crawled out of the cave and said women were entitled to equal protection of the laws under the Constitution. 1971, here's from the brief of Idaho. Statutes specifically preferring males to females have been applied whenever they have come before the courts, and cited a whole bunch of cases since 1845. The constitutionality had never been questioned. The 14th Amendment was not enacted to prohibit the enactment of laws making a distinction on the basis of sex. Nothing in the vague generalities of the equal protection or due process clauses enables this court to nullify what the elected representatives want. Like I said, with all of these, just replace right to choose. Do we have time for other cases? Just a few more? Okay. Kennedy, this is another huge one. This is a huge one that was decided this year. In this case, you had the football coach goes to midfield, kneels down, says a prayer, encourages the team members to come pray with him. And the question was, since he is an official of the school, a public high school, doesn't this violate non-establishment in that you have a government employee, a government official on government time in a government place praying and gathering the teammates to pray with him? 6-3. No, it doesn't. And Neil Gorsuch writes the opinion of the court. Now, one thing that's curious about this is Chief Justice John Roberts assigned it to him because Chief Justice Roberts assigns who is to write the opinion, unless, of course, Roberts is in the dissent. He assigned it to Gorsuch. Well, not only did Gorsuch say that, well, and Sonia Sotomayor disagreed with him with this, well, the coach really never did kind of encourage or pressure the teammates at all, to which anybody who's on a sports team said, wait a minute, do you have any idea what it's like to be on a team and you got a coach and the coach is doing something? You're not going to want to do this with the coach? Anyway, Gorsuch says, well, he never really encouraged or pressured them, and that was controversial in the fact pattern. But then he went further, and he said the only thing that non-establishment in the Constitution prohibits is coercion, is actually forcing somebody to do something religious. That's the only thing that's prohibited. And he overruled, he said, and it's pretty clear, Lemon versus Kurtzman, this court doesn't follow it, and let's just be clear, it's overruled. Lemon versus Kurtzman is a landmark case by Chief Justice Warren Burger, no liberal he, saying that when it comes to non-establishment, you look at three things. Three things. You look at the purpose of what government is doing, the law or the activity. Is the purpose religious? If it is, it violates non-establishment. Is the substantial result religious? It violates non-establishment. Does it require the entanglement? Government to get involved? Like, are we going to have to send a government official into Catholic school to make sure that the nuns teaching history aren't teaching about the Catholic missionaries? He said that creates too much government involvement, entanglement with religion. Purpose, effect, entanglement. Any one of those, then there's a violation of non-establishment. According to Gorsuch, Lemon v. Kurtzman is out. I don't know what he means by this. I'm sorry, I'm not sure he knows what he means by this. Because the next case that we get with the actual purpose, like some legislator is stupid enough to stand up and say, the reason we're doing this is to promote religion. You're going to get a case, and what is Gorsuch going to say? We're not looking at that anymore? I don't know what he's going to do. Anyway, so Lemon v. Kurtzman, according to him, is overruled. Sonia Sotomayor, in dissent, said, apparently, non-establishment of religion is now unconstitutional. And that's basically what this court has been doing. New York Rifle and Pistol Association, gun rights, again, 6-3. And this had to do with the Sullivan Law in New York. The Sullivan Law in New York, which was a law from the early 1900s, required anybody who wanted to carry a firearm outside of their home, you had to go to the town clerk or the police department and go get a license, and you had to show proper cause. Well, two things. Number one, if the Second Amendment actually does provide for an individual right to bear arms, and I'm sorry, that's just a lie. There is no serious objective scholar that will tell you that's the purpose of the Second Amendment. They might say to you, well, the founders, the framers of the American people have thought that the individual right to bear arms does exist and ought to be protected. But that's not what the Second Amendment was about. The Second Amendment was to protect the states against the possibly tyrannical central government by allowing them to have their own well-regulated militias. But, Scalia fudged. And so we have the individual right to bear arms under the Second Amendment. Once you have that, once you have a fundamental federal constitutional right, you can't put the burden on the individual to exercise it. You can't say, well, you want to exercise free speech? You've got to show us you've got a proper cause. You've got a special need. You want to exercise your religion? You've got to show us you've got a proper cause, special need. So once you accept the Heller decision, where the individual right to bear arms is a fundamental right, this just flows. This just flows. New York can't require an individual who wants to exercise his right to show that he should be allowed to exercise his right. No, the government's got to show you, come up with a compelling reason why we can't allow you to exercise that right. Another thing to put this whole thing in perspective, the Sullivan Law. I don't know if any of you are familiar with the Sullivan Law, but the Sullivan Law, again, was enacted in the early 1900s. And it was a bigoted law, as are many of these things which liberals like today. It was a bigoted law to make sure that my ancestors didn't have guns, to make sure that new Italian immigrants didn't have guns. And later on, when Italians were kind of accepted, the law was used and continued to be used as an excuse to arrest minorities. You couldn't get them for anything else. If you found the weapon on them, you arrested them for that, and then you could search them for drugs or anything else. All right, so the Sullivan Law doesn't exactly have the best of pedigrees. West Virginia versus EPA, 6-3 again. I mean, what can I say? 6-3. How is it possible this is a Republican versus a Democratic thing? The Environmental Protection Agency came up with regulations about how much carbon can be emitted by the states after a certain number of years, and the majority of the court applied what's called the major question doctrine. In other words, this is such a major policy change. This should be done by the legislature and not by an unaccounted independent agency. Of course, the reason why we have the EPA and other agencies is so they are independent of politics and partisanship. Okay, the vaccine mandate, again, 6-3. How is this possible? Biden administration says any employer with more than 100 employees must be vaccinated or tested, and they threw that one out. Again, OSHA, they said OSHA, the agency didn't have that authority. Let me go through, this one. This one is, I find this one pretty disgusting. You'll see that the Chief Justice joined the liberals. In this case, you had a federal district court in Alabama said, you know, the redistricting you did, you gerrymandered on the basis of race. I can't say this beyond a reasonable doubt, but it's pretty darn clear that's what you've done, and I bet after a trial, that's what we're going to find. So I'm not going to allow this racist gerrymandering to go into effect. The majority of the court, 5-4, in their shadow docket, which several of them say doesn't exist. And what that means is the court summarily accepts the case, doesn't have any oral arguments, and then issues an order. Nobody signs it, you'll notice. And it's usually some little ditty, you know, a few paragraphs long. They overruled what the federal district court did, and they said, no, that redistricting goes into effect. Why? Why would you do that summarily? Why would you do that when a trial court has found that it's almost certainly to be racist? And this is the Texas law, right? The Texas law. If you sue anybody that's assisting, aiding in any way somebody getting an abortion, you get $10,000. And so, again, the shadow docket, they said, no, we're not going to stop that law. We're not going to stop it from going into effect. Let it just go through the regular appellate avenues. The Chief Justice joins the liberals again. He says, wait a minute, we've never seen anything this bizarre. There are all kinds of constitutional questions. We ought not to allow it to go into effect until we've had an opportunity to examine it. But again, Thomas, Alito, Gorsuch, in this case Kavanaugh, and Amy Coney Barrett. Trump versus Thompson, whether or not the former president still has executive privilege, so he doesn't have to respond to a congressional subpoena. The court said, no, he doesn't. The shadow docket, Thomas, he dissented, but he didn't say anything. There's just a line, Justice Thomas dissents. It should have said Ginny Thomas dissents. Well, I don't know about that. Any event. One criminal case, Miranda violation. It was a Miranda violation. Custodial interrogation, Miranda rights were not violated. Were not recited. Then the facts are all muddied. But in any event, the accused gets acquitted and he sues. He says, hey, you violated my Miranda rights. And he sues under 1983, which is a constitutional tort, meaning your constitutional rights are violated, you get to sue in federal court. 6-3, the court said, sorry, Miranda rights are not constitutional rights. Miranda is just a protection of a constitutional right. It's just a protection of the right against compulsory self-incrimination. But itself is not a constitutional right. All righty, let me just go through. There it is, what it's been. That's just flipping it over. Frequency in the majority, Robertson, Kavanaugh at one end, Breyer and Sotomayor at the other. Flip it over, dissents, Robertson, Kavanaugh virtually never. Breyer and Sotomayor half the time. Concluding prospects, 74 years, the average is 81 or 83, whether it's average or median, 27, 28 terms on the court. 31 years, but he's still young. Alito, 16 years, still young. None of the rest of them anywhere near that. None of the rest of them are anywhere near that. That's what it's going to be like for the foreseeable future. Just think of these issues and how the court's going to vote with a 6 conservative majority. And that is it. Thank you so much. Thank you. And I'm more than willing to entertain any question about anything. Yes, Gloria.
Well, I have a question from the Zoom audience, and it is in regards to gun regulations. How is New York State's new regulations in response to the Supreme Court ruling not equally unconstitutional?
Well, if New York adheres strictly to regulating the time, the place, and the manner, and it does that in a very narrow way, that should pass constitutional muster. We do that with every right. Think of freedom of speech. Talk about time, right? You're not allowed to protest Trump or Biden in a residential neighborhood at 3 o'clock in the morning, right? Place, the residential neighborhood, manner. And you can't do it in a residential neighborhood, perhaps even at dinner time with a megaphone blasting so that the people's peace is disturbed. So time, place, and manner is usually an exception to regulating constitutional rights. The problem with the New York law, and you knew there were going to be problems, it speaks in terms of public places and public parks. Okay, the Adirondack is a public park. Now, I don't know how much of the bill had been changed, but the Adirondack is like almost half of New York State. And there are lots of people that live in the Adirondack Park, lots of people that hunt in the Adirondack Park, do all kinds of activities in the Adirondack Park. Most of the Adirondack Park is completely desolate. I cannot imagine the United States Supreme Court upholding that kind of a restriction, if it's still in there. Apparently the one for the Catskill Park is still in there. So it's probable that New York went overboard, but some of the restrictions almost certainly ought to be upheld. Yes?
A follow-up on that. What about the social media review component?
Oh, well, I would think that would have some First Amendment problems that New York is going to, wants to review. I think if somebody applies for a license, that person's social media can be reviewed. It seems, well, let me put it this way. It seems very, very unlikely that you're going to get 5 votes on the United States Supreme Court to ever allow that. This court is very, very strong on free speech, free expression. I can't imagine it allowing that. There were other questions? Yes, go ahead.
Just a quick comment and then a question. In all the cases that you presented where precedent was overturned, I think in every one of them, precedent was overturned to give a right that previously had been denied. Dobbs scares people like us.
Yes.
Because and I'm married to my partner for 40 years, so I'm very scared that a right that the court gave us is going to be taken away. And so the danger is immediate, I think.
Yeah.
So then my question is, what's the potential solution? I mean, an amendment giving term limits doesn't seem like that would work. But packing the court up to some ridiculous number, 15 justices, would take an enormous amount of power away from the court and give it back to the rest of us who want our rights protected.
Right.
So is court packing an option?
Well, let me start from the beginning. First of all, I hope I didn't sound like I was diminishing the impact of Dobbs. I mean, I think it's an absolutely dreadful decision. I just think the arguments on both sides were not very good. There are profound interests on both sides, and it doesn't seem as though either side was willing to get in there and actually balance the interests. Instead, they came up with these arguments, not in the text, not part of history and tradition, or this was, a 50-year precedent. Not terribly strong arguments. But the Dobbs decision, I mean, it's dreadful. With regard to, has the Supreme Court ever done this before? Well, it depends upon whose ox is being gored. Employers certainly thought that their rights were being taken away. In 1937, when the United States Supreme Court started to uphold all these social welfare rights. Now, social welfare is an ameliorative term, because I happen to like those bits of legislation, right? Maximum hours, child labor laws, worker safety, consumer safety, all those kinds of things. But, on the other side, it's property rights. This is my property, for crying out loud, and you are interfering with my property. You are telling me I cannot use my property the way I want my property used, right? So the civil rights cases in the late 1960s, which upheld the civil rights laws of 1964 and 1965, the public accommodations laws, which said no racial discrimination in public accommodations, meaning not accommodations owned by the government, but accommodations that were generally open to the public, hotels, motels, restaurants, transportation carriers. That you can no longer discriminate on the basis of race. And the United States Supreme Court upheld that. It upheld that on the basis of the federal government's interstate commerce power. Why did it do that? Because in the late 1800s, this is after the 14th Amendment was ratified in 1868, and which contained equal protection component, the United States Congress also passed public accommodations laws, civil rights laws. And the civil rights cases back in the late 1800s, the Supreme Court overturned all of those. And it did so on the ground that, no, private property owners have rights. They're allowed to decide who they get to serve, who their customers ought to be. Now, if you're a business person, if you're a property owner, you might think that after 1937, many of your rights were taken away. And in fact, today, what is true, whether it's a good thing or a bad thing, property rights are virtually not protected at all by the United States Supreme Court. When you have a fundamental constitutional right, and they have to put that label on it, fundamental constitutional right, speech, religion, press, counsel, self-incrimination, jury. When you have those, if any government, federal, state, or local, tries to abridge, restrict one of those rights, the government must prove, number one, it's got a very strong reason for doing that. We call that a compelling government reason. And number two, the government better show that's the only way it can accomplish what it needs to accomplish. So it's a national security reason. But can't you do it some other way? Well, yeah, we can. Okay, then you can't do it this way and abridge the fundamental right. With regard to property rights, since 1937, as long as the government comes up with some rational basis. No, I'll go further. It's worse than that. Even if the government doesn't come up with a reason for what it's doing, restricting, regulating property, the court will hypothesize and it will imagine some reason why the government could have done that. Let me give you an example of how this works, this so-called routine scrutiny rational basis, and how it worked with a case that has been overruled by now, but not too many years ago, 2006, Hernandez versus Robles at the New York Court of Appeals, an absolutely disgraceful case, had to do with same-sex marriage. The New York Court of Appeals ruled against same-sex marriage. How did it do that? Number one, it interpreted the state's domestic relations law as prohibiting same-sex marriage and only allowing opposite-sex marriage. The court itself interpreted the statute that way. Then what did it do? It had to find some legitimate reason that the legislature could do that. Of course, the legislature didn't do that. The court did that. So it had to hypothesize a reason why the legislature could have wanted to prohibit same-sex marriage. And of course, the majority came up with all kinds of homophobic reasons. Opposite-sex marriages are unstable, unlike heterosexual marriages. Same-sex couples, the legislature could have thought they'd be terrible with kids. The kids would be all messed up. Of course, first of all, there's no study that shows that. But number two, that wasn't even an issue in the case. So the court just hypothesized possible reasons. That's what the court does with property rights. If there's an abridgment of property rights, the court does not apply that high standard that it does with political, civil, fundamental rights. It applies this routine scrutiny. Come up with something, and if you don't come up with something, we'll hypothesize some legitimate reason. Okay. The other part? Court packing. Presidents always try to pack the courts in different ways, right? I mean, obviously Trump packed the court, right? I mean, an unpopular president, he was only in office for 4 years, and together with Mitch McConnell, they packed the court by filling 3 vacancies, right? At the beginning of this country, there were 6 justices on the United States Supreme Court. After Jefferson beat Adams in the election, the Federalists in the Congress, they reduced the number of the Supreme Court down to 5 because they didn't want to give Jefferson a vacancy to fill on the court. Then he increased it to 6, and went up to 7, 8, 9, 10, 11, and then it came back to 9. Finally, with Ulysses Grant, it went to 9, and it stayed at 9. There is nothing magical about the number 9. Nobody has ever done some study to suggest that a court is wiser with 9 members on it. Nobody has done that. But like so many other things that become part of our history and tradition, they become almost sanctified. Now, packing the court. Okay, suppose the Democrats now in control, they somehow got up the nerve, whether it's a good thing or a bad thing, to pack the court and add 3 seats to the court. Okay, what are the Republicans going to do? I mean, you know what they're going to do the next time they're in power, right? And you know within the next 10 years, well, it's near certainty they're going to be in power at some point over the next 10 years. They're either going to reverse that or they're going to pack the court even further. So I don't know about that. There are some very serious proposals. One of them, the most serious, which has been bandied about for a long time, but it's finally getting an awful lot of attention, is to limit the terms on which the justices may serve to 18. You say, why 18? Well, it's been figured out arithmetically that if you do it this way and stagger the initial terms, in every presidential term, there will be 2 vacancies. So whoever is president for that term gets to fill 2 vacancies, as opposed to Carter gets to fill none, Trump gets to fill 3, Clinton, Obama, 8 years and they only got 2, right? This way, it's consistent. Okay, what are the problems with that? Well, there shouldn't be a problem because the Constitution does not say that the justices get to keep their position for life. It does not say that. Maybe the Supreme Court or majority would rule that it says that, but it doesn't. It says good behavior. That's the way it is with judges and justices everywhere around the country. Meaning, you can only be removed, you can only be impeached for bad behavior. But it doesn't necessarily specify an amount of time, a specific amount of time on which the justices must be kept in office. So I think that's a real serious proposal. Will it ever get past the Congress? I don't know. I doubt it's going to get past the Congress this time around. Maybe Maybe in our lifetimes it might get through. But then you got to go to the Supreme Court and then see what they do with it, right? What is Justice Thomas going to do with it? By that time, he will have been on the court for 70 years. What? Yeah, well. Or at least he loves his RV. He and his wife apparently love to travel around the country in RV. Let me say something about Thomas, because I said something nasty about Gorsuch. He's not well liked. That's been pretty well documented. Justice Thomas may be the most liked guy in the building. They say he's warm and wonderful and sweet. The staff all love him. I've heard that from all kinds of people, all different sides of the spectrum of the court. He's apparently a really nice man. Yeah, I know. And look at that vote, 8-1. Justice Thomas dissents. You want to give us a reason? You know. Yeah. No, I know. Well, hey, that's a third of the country, so you know. Yeah. Anything else? Yes, go ahead.
Is there any, going back, has there been a period of an apolitical court or courts? Does anyone?
Yeah. That's actually a fantastic question. No, the court's always political. Is it always partisan? No, that's the difference. This is a partisan court. They keep insisting we're not partisan hacks. Yes, you are. Both sides. You vote like partisan hacks. Now, at the very beginning of the Republic, Washington and then Adams put all Federalists on the court. Okay? Were they partisan? Well, at the very least, they voted the way Federalists would like, meaning that they interpreted the Constitution and they formed what we now view as the Constitution in a way that would help business, right? That would strengthen the federal government against the states. These are things the Federalists liked, that the Jeffersonians hated. So, of course, when the Jeffersonians won, right, after Adams packed the court with the midnight appointments, right, after Jefferson won, he started to put Jeffersonians on the court. Can you imagine you start your own party and you call it after yourself? Well, I don't think he called it the Jeffersonians, but the Jeffersonians, right, Jefferson, then Madison and Monroe, they would put Jeffersonians on the court who trusted the rural voters and trusted the farmers much more than they trusted the urbanites. And they trusted the states more than they trusted the federal government. Of course, they had good reason to do that because, among other things, and one of the main reasons why Thomas Jefferson hated the federal judiciary is because they allowed the prosecution under the Alien and Sedition laws. And they upheld convictions under the Alien and Sedition laws. And Jefferson, the Jeffersonians, thought that was a real violation of freedom of speech. Well, of course it did, because it was Jeffersonians that were complaining about Adams, right? So it's always political. The questions are always political. They're about individual rights versus responsibility. They're about government power versus individual freedom, right? It's always about that. The difference is partisanship. So, for example, when all the members of the Supreme Court had been appointed by Franklin Delano Roosevelt, right? All of them had been appointed. They were divided over all kinds of things because they were divided over judicial philosophy. They were divided over how do we go about interpreting the Constitution. They were divided over what do we do with dual sovereignty? What's the balance between the federal government and the state government? How much should we be deferring to the Congress? They were divided over that. That's not what they're divided over today. They're divided over partisan issues. Think about it. If you're a real conservative, right, you believe in local governments, you wouldn't have overturned the New York law, right? You wouldn't have overturned the New York law. If you really believe in deferring to the other branches of government, would you throw out laws like the gun rights law, the federal gun rights law, the Brady law? Would you do that? Would you throw out campaign finance restrictions? No, you wouldn't do that either. That's not what they're about. If you were an originalist, Would you construe the Second Amendment as enshrining individual rights? No, you wouldn't, because that's not what the amendment was about. But if you're a conservative Republican, right, if for whatever reason that whole host of issues you prefer the conservative Republican way or preference on those, right, then that's the way these justices, 6 of them have been voting, and sometimes not Roberts and Brett Kavanaugh. And liberals, right, Sonia Sotomayor, Ginsburg before she passed away, and Stephen Breyer, voting like liberal Democratic politicians all the time. So, yeah, always political because that's the nature of the cases they get, but not always partisan. Gloria?
There's another question from the Zoom audience. Is it possible that Roberts and Kavanaugh will feel so guilty about what this court has wrought that they will increasingly join the liberals to create more close cases going forward?
Your question to God's ear. Yeah. I don't think there's any question that Roberts is already feeling that way. Roberts is, you've heard it, he's an institutionalist. He's really concerned about the respect for the court, the place of the court in America, and he's well aware of the fact that this court itself is just out of the mainstream with American life. And this court has been ruling in certain ways that not only are contrary to what most Americans want, which should not be decisive necessarily, but it's contrary to a fair reading of the law. It's contrary to a fair reading of what the court has done throughout its history, right? So, yeah, I think Roberts will do what he possibly can, and maybe, and it's, I know, a hope for many of us, that Roberts will be so repelled by what Alito, Thomas, and Gorsuch are doing that, like Sandra Day O'Connor and Anthony Kennedy, he is going to drift over to the left. He's never going to be a liberal, right? He's never going to be a liberal. Well, he might be a liberal, but it's unlikely he'll be a liberal, but it's certainly more than likely that he will become increasingly moderate and less conservative. Yes?
Just on a more philosophical or sociological level, some of the concerns and the actual decisions are taking the country backwards. Sociologically, we know that those societies that do not come to where the people are, so to speak, will fail. Can this be avoided at this point? Abortion is not going to stop. The attempt to vote, hopefully, is not going to stop. Same-sex relationships are not going to stop. What's going to happen to the society?
Well, first of all, the last time we had a court that was like this, that was so far out of the mainstream of the American voters, right, was again in the New Deal. And ultimately they changed. One, maybe 2 justices on the court realized what was going on and they changed. Maybe that convinced them. With regard to abortion, for example, and I think this might be emblematic of what might happen with other things. As with gun rights, somebody was asking me about gun rights. We are going to have a whole bunch of abortion cases, a whole bunch of them. And there are going to be cases that are going to be extremely sympathetic to the women who wanted to get an abortion, right? Or who couldn't get an abortion and something tragic happened to them. Or there are going to be, there are going to be states that are going to go overboard. Suppose we get a state that says, look, we believe that God Almighty has infused the zygote at the moment of conception with a divine soul. And it's a person, and therefore there cannot be any abortion from the time of conception. I don't think you're going to get a majority of this court to uphold that. I think you're going to get Thomas, Alito, and probably Gorsuch, but I'm not sure you're going to get a majority of this court. The states are going to go overboard, and the court's going to cut back. I tell you, the Dobbs decision is a terrible decision, not just the result. The entire analysis is awful. And we are going to see the court cut back on the analysis. And the same thing with gun rights. You're going to see restrictions that are finally upheld by this court. It's going to happen. They read the newspaper, they listen to the news, they think twice about what they're doing. Some of them may not think twice about it, but most of them do. So I think the court itself will ameliorate itself.
And with that, I think we should end. So thank you so much.
Oh, thank you. Oh my God, thank you. What a great audience. I told you guys were the best audience I ever. Oh, really good. Very, very good.